And lawyers, guns, and money.
Dan and I are recording this on Tuesday, and just before we started recording, a tweet was sent to me by a couple people, by President Trump, who mentioned that he had what he called a productive conversation with Big Ten Commissioner Kevin Warren, who's been, we'll say, the target of a lot of attacks of people that are calling for his job, that he maybe was the spearhead of a premature cancellation of Big Ten football. And even those that are okay with him canceling it, they just want to understand the reasoning. So parents and players that we're going to get into are just looking for answers, be it FOIA requests or be it lawsuits. And now, Dan, because you, and I'm going to give you the credit for this, you are in addition to being a fantastic lawyer, you're a fantastic investigative journalist. And Dan got his hands on a copy of a document that I don't think has made its way out yet, but that is a copy of the Nebraska's opposition to these
Big Ten's opposition.
I apologize. The Big Ten's opposition to the Nebraska players. We'll say emergency application for an injunction, emergency discovery. But Nebraska, Big Ten yesterday filed their papers, and Dan, through his various channels and various detective work, was able to get a hold of that. So Dan, the floor is yours. Break us down on the latest development in this Nebraska players lawsuit against the Big Ten.
Well, sure. I don't know if the investigative techniques that I used were all that uncommon. I simply emailed Andy Luger, who's a defense counsel for the Big Ten, and he sent me a copy of the brief. So
why do you tell people what your tricks? Why don't we you're just a magician? That's you got to go with.
Because just when you think you have the answers, I change the questions. So that's one. Who said that? Do you know who's famous? Whose line that is?
You can't handle the truth.
No, Rowdy Piper on Piper's Pit, going back to the 80s.
Okay, wrestling stuff.
He wasn't a lawyer, but the great late Rowdy Piper, came up with that expression. Just when you think you know the answers, I change the questions. Anyway, moving forward, I think yesterday's court filing by the Big Ten exposed or highlighted the mootness of this lawsuit brought by the Nebraska players. I've been fairly vocal on Twitter about what I think of the merits of this lawsuit. I think it's deficient because it's based on legal claims that haven't ripened yet, or that don't exist because collegiate athletes do not have contractual rights or third-party beneficiary status by virtue of the governing documents of an athletic conference. There's no direct contractual relationship, and courts have held that. So I was waiting for the Big Ten's response, and the Big Ten, I think, highlighted the fact that the relief that the Nebraska players are seeking has already been satisfied. The main things that the Nebraska players wanted to know, and this is from the words of their own lawyers, is that they want to know whether there was a vote, the details of the vote, and whether the Big Ten followed its own rules in reaching its decision. The Big Ten came through in flying colors on all three counts. They provided the vote, the details of the vote, and the Big Ten bylaw provision, which shows that the power to determine any reduction in the number of games is vested exclusively within the Big Ten and requires only a 60% vote, which is the highest threshold under the bylaws, but requires a 60% vote to carry forward. And here there was an 11-3 vote in favor of cancellation, which is more than the requisite 60%. And this is backed up by all these medical details and a doctor's report from, I think, Ohio State medical expert indicated that some of the preliminary testing that had been done indicated a very high rate of heart-related issues with the collegiate players that did test positive. I think there was a 15% of all positive tests showed or revealed, I'm not sure if I'm saying the condition correctly, but a serious medical condition that could have long-term ramifications. So I think the Big Ten did the prudent thing here, but more importantly, from a legal perspective, I think the Big Ten eradicated or answered all of the questions that were raised by the lawsuit.
So, Dan, we don't normally disagree, but I just want to push you on one an interesting point. So Dan and I didn't get a copy of all. We saw the brief, we saw the exhibits. So just so people are kind of understanding what Nebraska, the players had laid out, they pointed out three administrators with the schools. That's Joan Gabel, the president with Minnesota, said that that a vote did not take place. Samuel, I think it's Stanby or Stanley at Michigan State. He's the president. He said that a vote did not occur. And then the athletic director at Penn State said it was unclear if a vote occurred. So those were their allegations. And in response, Nebraska players, they want to know exactly what happened. What the Big Ten said in response, they have an affidavit, a sworn affidavit from Morton Shapiro. I think it's a weird spelling of Shapiro, but I think that's how to say it. This is like Mark Shapiro, who's the former, he was with the Indians, but in any event, so he's Morton Shapiro is the chairman of the Big Ten. He's the president of Northwestern. He swears under oath that a vote occurred. The vote was 11-3, and he swears that this vote occurred. Now, I've kind of pointed this out on Twitter, right? If you want to provide full transparency, I mean, you're not really under an obligation, at least as far as anything in the bylaws that we've seen, to provide who voted where, who were the 11, who were the 3. I think some reports have trickled out that the 3, this is just from what I saw on Twitter, I don't believe these are confirmed, but that it was Iowa, Ohio State, and Nebraska was the 3rd. So to me, I still have some questions, right? How was Minnesota saying that a vote didn't occur? The president, right? And to be clear, this is the council that's voting is called, Big Ten Council of Presidents and Chancellors. So the presidents and chancellors are in theory in this room, right? How is the president of Minnesota, how does she not know if a vote occurred, right? How does the president of Michigan State not know if a vote occurred? How is Penn State saying it's unclear if a vote occurred? And then on the other hand, and I understand that these are their filings, right? This is the Big Ten's lawyers putting this forward, that they are, and under sworn oath, a vote occurred. It was crystal clear. It was 11-3. I still have some questions that I don't think are answered necessarily by these filings.
Yeah, but Dan, just like the Nebraska players, you and I don't have a right to intrude into the private decision-making and affairs of what's a private business corporation. This is not a public company. This is a private association which under the law has certain freedom from, intrusiveness from outside parties. I understand that the coaches, the players, the parents, maybe even some university, high-level officials want to play football, but the Big Ten is under no obligation to provide, transparency into its vote. That's why it's a private association, and certainly it's done more than enough so far, because this is whether or not a vote has occurred. I think that's been answered, and I haven't heard significant proof, pushback or proof that no vote occurred. This is a commissioner who's a lawyer, and there are many people involved in these phone calls. Maybe if some of the university presidents are doubting it, maybe the people on the calls were athletic directors or lawyers. It would be nice to see affidavits in response disputing whether or not the vote is occurred. I know that the Big Ten has gone under oath. To the extent that there's any doubt from any of the participant members, then I'd like to see affidavits to the contrary. But in the absence of that, I think the Big Ten has carried its burden. And I want to speak a little bit about this lawsuit. I think the way it's...
Before we get there, Dan, just quickly, because I want to get into the actual lawsuit too. There is some stuff there. And Dan, I penned this. Dan had a great tweet yesterday, took this from the motion. This is a discovery motion in search of a case. That's directly from the Big Ten's brief. But I just want to, before we get off here, I mean, Dan, there is, as much as this is not, like, there's a question, right, about the legal sufficiency of the case, which I do want to get into. But then there's this, the quieting of the noise element. I saw this morning, the Trump tweets that he met with Kevin Warren. And to me, right, maybe, Dan, you're under no affirmative obligation as a private institution to provide full transparency. But I don't think it sends the right message, right? If you have parents who are writing letters to school, right? I've been tweeting these different Illinois, letters from different parents associated with schools. And then you have players suing the school, right? And we'll get into it. But your position is that you're not under an obligation to provide this discovery, right? But meanwhile, Kevin Warren, the commissioner of the conference, is publicly, it's out there, that he's met with President Trump and had a 15 to 20 minute conversation. So you're providing the transparency to the president of the United States, but not to your own parents and players. I don't think that sends the right message for the Big Ten. And it's going to invite in lawyers like Tom Mars sending these FOIA requests to, Dan, 13 of the 14 schools in the Big Ten are public institutions, and we'll have to answer that discovery. So I don't think it makes sense to fight it here but allow it over here, if that makes sense.
Well, I'll agree with you on the transparency issue. While under no legal obligation to provide details surrounding the vote, I think it would have been probably a wise thing, at least, or the practical thing, to at least, if you're going to announce the cancellation of the season, say that a vote occurred, the vote was 11-3. I'm not going to tell you who voted what, but the vote actually did occur.
He's coming out a month later.
And I think Kevin Warren flunks the transparency course. F. He gets a grade of F because he could have nipped this controversy in the bud by providing the same details that he provided yesterday in a court filing, but providing them a week or 2 weeks ago. I think it would have nullified.
No brainer.
Yeah, it would have been a no-brainer and would have nullified some of these items. And I don't put much credence in a public records request or a FOIA request, because those responses are within the exclusive control of the universities. They are under maybe a statutory obligation to provide responses within X number of days. But you know very well, and I've been on both sides of public records requests, there are a number of statutorily recognized exemptions. And the most common one would be the exemption for trade secrets, the exemption for proprietary business or confidential or financial information. And all of these records surrounding the Big Ten playing football or not playing football, I think you could group those into the category of being commercial information or sensitive commercial and business information. So the first step or the first response of any of these public schools, and I know I've dealt with public universities, both representing them, being aligned with them, and being on the other side, is that response is going to come on the last day of the statutory deadline, and it will say exempt from disclosure, because it's proprietary commercial information and/or trade secret. So all that does is waste everybody's time for a month. And if you're gonna compare the public records request versus an actual lawsuit, a lawsuit can accomplish so much more because you have the availability of judicial relief almost immediately, whereas a public records request basically places the university or the public agency in almost full control of the timing for the first 60 days.
So that's a good segue here. My inclination in this Nebraska suit, and as much as I'm all for player empowerment, I'm all for transparency. My inclination is that this Nebraska players lawsuit was designed as another, we'll say, to surround Big Ten from another angle, right? Tom Mars has his FOIA request to, I believe it's all, at least all the public universities, that's the exception of Northwestern, for this information. And Nebraska is asking for expedited discovery. So you're going to get that. And if you fail to abide by a discovery order, there are sanctions of contempt. And a lot, as Dan said, you have an actual framework of discovery, right? If you don't listen to the FOIA request, it just wastes more time when we're talking about a potential, maybe even a Thanksgiving start for Big Ten football. That time frame doesn't really make sense. So Dan, let me kick it back to you. Let's talk about the substantive merits of this lawsuit.
Well, I think this request for expedited discovery is a wolf in sheep's clothing. What it really is tantamount to the equivalent of a motion for a temporary restraining order or preliminary injunction. They're seeking immediate relief before so much as an answer has even been filed, and they're seeking, before an answer has been filed, to get discovery within like 5 days, when typically the normal time frame for responding to discovery is 30 days. And then, of course, that only happens usually after a substantive answer has been filed. So let's get into the reasons why the lawyers for the Nebraska players filed this as a discovery motion rather than a TRO. And I think I made the point on Twitter. They're claiming irreparable harm from not having this information. And obviously the first step, or the logical first step, would be to seek ex parte relief in the form of a motion for a TRO. The reason I suspect that the players didn't pursue preliminary injunctive or TRO relief is that any decision, whether it denies the motion or grants the motion, is immediately appealable even before the case is over, meaning that the Big Ten could appeal a TRO requiring release of this information and take it to the Nebraska Intermediate Appellate Court, or maybe even the Nebraska Supreme Court. And just the mere existence of that automatic appellate remedy would moot the entire lawsuit, because then, as we're seeing in the Zion Williamson case, Williamson appealed the denial of personal jurisdiction as an interlocutory order and basically put the Florida case in his rearview mirror because of all the time delay. If the Big Ten is able to successfully appeal a TRO grant, this case is, for all intents and purposes, over, because it would not be resolved on appeal until, in all likelihood, the end of what exists of this college football season. So they went the route of a motion for expedited discovery, which I think is might be tactical brilliance, but it really is insincere and disingenuous. What they really should be seeking is emergency injunctive relief. And I don't think that they've met the standard here for expedited discovery, because they can't demonstrate a likelihood of success on the merits, which, while that's one of the elements for a temporary restraining order, I think in order to address pre-answer discovery, having a preliminary peek at the merits is essential. And the two substantive claims that the players have raised, I believe, are legally deficient. Their tortious interference claim is predicated on Nebraska's Fair Pay to Play Act, which has not even been implemented yet. So basing a tort interference claim on a non-effective NIL law, I think is deficient in and of itself. And the breach of contract claim is based upon alleged third-party beneficiary status as a result of the Big Ten bylaws. The players are arguing that the general language in the governing documents between the conference and the member schools create contract rights in and to the players. And that theory has already been rejected. As I highlighted on Twitter, and I think on our Instagram broadcast, there is a case directly on point called Hairston versus the Pac-10 Conference, where the Ninth Circuit affirmed the dismissal of a breach of contract claim brought by the players against the Pac-10 Conference that was predicated on the Pac-10's bylaws being the contractual hook. And that's exactly the same theory that the Nebraska players are pursuing here. So not every remedy follows a legal right. If the legal causes of action are deficient, then you don't have any lawsuit. So in essence, or in truth, it really is a discovery motion in search of a case.
So, not that I disagree with you. I largely agree with what you're saying, Dan. I think there's some, I'm going to say, kind of palpably unfair, right? And I'm going to kind of speak for a lot of our fans that not necessarily lawyers on Twitter, but are very vocal that they want answers about what's going on in the Big Ten. If Dan, you are the Nebraska players, right? And Kevin Warren, up until that point, right, had been, there's been zero transparency, right? We didn't even have 11-3, right? And even the schools, that's the schools that I'm saying, Iowa, Ohio State, Nebraska, that's not in this brief. It doesn't say the exact schools that were those three. So if I'm a Nebraska player, before I want to file a TRO, I want some answers, right? I want some discovery. I want to see what happened. And even now, Dan, I'm just playing devil's advocate here. I don't know if I actually believe this, but we got a statement, obviously Kevin Warren, and we got it was Morton Shapiro, who's the chairman and he's president at Northwestern. That still doesn't answer my questions. It doesn't answer my question. Maybe I'm not entitled to them, but if I'm going to have a lawsuit, Dan, and I know you and I spoke about this in a previous podcast, in order to disrupt the, we'll say the rules and bylaws of a private institution, you need some evidence of egregious conduct. But how am I going to get the evidence of egregious conduct if you guys are keeping all of your mouth shuts, right? If you're doing a unified front, no one's saying anything, how am I supposed to see if there's egregious conduct? So I think it's a smart decision to move for emergency discovery, because they need to get some answers and they need to get it fast, because football is right around the corner. We had our first college football games, this past week. So I think it was almost a necessity. I understand 100% why they went that route.
Yeah, but the law is very well settled in this area. I know, you and I may want answers, players want answers, and I'm ordinarily 99.9% of the time sympathetic to players' rights. I tend to, lean heavily on the side of player rights versus the, leagues, teams, the institutions, and my record is redoubtable on that. But in this case, the law is a fairly significant barrier, and the courts have historically deferred to the decision-making of private associations and have been loath to interfere with that decision-making, barring unless certain exceptions have been met. And one of the exceptions, and in fact, the exception that was raised by the players in their lawsuit, is that the Big Ten failed to follow its own rules. And
But
what we learned,
there might be some evidence of that, Dan, because again, they didn't correct. This is just the lawyer, journalistic, whatever. There are three individuals with we talked about Joan Gabel, Minnesota, Michigan State, Penn State, who are sending pretty clear signals that they don't believe a vote actually occurred. So now you just have an issue of credibility. But I think there is some evidence that a vote, if they're saying a vote didn't occur, a president who should be in that room, two presidents. I mean, that's at least some evidence that they didn't follow their bylaws.
well, unless they're filing affidavits in support of the Nebraska players' lawsuit, statements made like that in the press are of absolutely no import in the context of this motion or in the context of this lawsuit. I think the Big Ten or the commissioner of the Big Ten has discretion to determine whether a vote has taken place, whether the rules have been followed. And I think what they've put out there in their formal legal response is, one, a vote has occurred. This was the vote. Here's who voted for, who voted against. Anything beyond that, such as getting at the medical evidence and all the other underpinnings of the decision, I think is beyond the purview of what's allowed, beyond the purview of the lawsuit, and I think intrudes upon the private. It intrudes upon the business of a private association. I think their allegations have been answered in large part with the production of this vote. And could this lawsuit have been negated if Kevin Warren had been more transparent early on? I think so, and I think it's a major failing on his part. But I just don't think that anybody can just demand these items and information from a private association. There may be political reasons and relationship reasons with colleges, with fans, with parents, with students. There may be an abundant number of good reasons to provide transparency, but legally, I think the Big Ten has already met its obligation.
So that's where, Dan, you and I see eye to eye. I don't, if you're going to provide this 11-3 vote, right, and you're going to meet with the president, just 2-3 weeks ago, right, you weren't providing any transparency. So I don't understand that unless something changed. Now, Dan, I want to note, in these exhibits, we were given a fully, basically an almost entirely redacted version of the bylaws, other than Article 5 of the Big Ten bylaws called the Board of Directors. So the one that is applicable here is Section 5.2. It's called Conditions for Actions to Take Effect and Assignment of Responsibilities. All actions relating to the following matters of the corporation meaning the Big Ten, are reserved to and may take effect only upon the vote of not less than 60% of the entire Board of Directors. So there's four different versions. The one that I believe is the one that's referenced here, it's number 3, subsection D. It says, again, a vote of 60% of the members has to occur in order to, and this is subsection 3, reduce the number of sporting events in a member's schedule. So essentially, you're reducing the amount of games to 0 for everyone across the board. So, Dana, again, we're the I'm wearing the plaintiff's hat.
I'll play devil's advocate. The key word there is reduction. I didn't see the word elimination or cancellation.
Well, reduction to 0 is.
Yeah, obviously. But if you're going to cancel the season, it's not a reduction; it's a cancellation of the entirety of the season. I think if I'm playing devil's advocate, I would say, well, you can, as Big Ten, you could decide whether you want to play 8 conference games or 9, depending upon TV rights and availability of other schools. I think those words could be construed to mean variation in the number, but not the outright cancellation. And
well, I would say a variation from like 11 to 0 would still be, still be a reduction.
Yeah, yes.
Right.
But this is not just semantics. I mean, it's not just semantics. They could, instead of the word reduction, they could have been used any alteration in the number of games played. No, reduction, I think, implies a diminution of the number of games, but not the cancellation. But I think the language is broad enough to cover cancellation. I'm just pointing out that there could be 2 reasonable interpretations of that word, for which maybe extrinsic evidence should be considered.
So what I don't, and I'll agree with you there, Dan, but I think there can't be 2 interpretations. That's the section I read first. There has to be a vote of not less than 60%. So for purposes of the Big Ten, in order to accomplish whatever Dan and I are arguing about, the semantics, reduction, elimination, for the Big Ten's purposes, that has to be 9 of 14 members have to vote for some type of change. So the reports, if you're just gonna, obviously I read everything on Twitter, verified, unverified, to try to get a full picture. The reports coming out were that there wasn't really a consensus on anything. Kevin Warren just said, we're gonna go this way, and everyone, I want to have this unified front. So the fact that now an 11-3 vote's coming out, again, as a plaintiff in a lawsuit, there is a motion in federal rules, obviously one in state rules, failure to state a cause of action. But on day one, right, you're not expected to have all of the information. That's why you have discovery. That's why you're allowed to have some form of depositions. I would say there's a very reasonable version that occurred that, maybe there was a somewhat of a consensus, maybe a vocal, one or two people that were vocal. Maybe it was even Northwestern and Kevin Warren that said we should cancel. And raise your hand if you really feel diametrically opposed to that. And then Ohio State raises their hand, Iowa raises their hand, Nebraska raises their hand. In that version of events, which I think is plausible, and I mean, again, everyone's all speculating at this point, but that's a vote of 3 people saying no and the rest either saying yes or being indifferent. That scenario, which I do think is plausible, would be an example of not following the Big Ten's bylaws, because that's not a vote of that's not a vote of 9+. That's a vote of 3 saying no and the rest being somewhere else. So I do think, Dan, I do think that everyone would be happy if there's additional transparency. Again, maybe under no legal obligation to do so, but as much as these are private entities, Dan, these are businesses, and they're in the business of getting top recruits, top families. And I don't think fighting
top families,
top families, Dan. You can't just be a good football player. You got to have the right pedigree. But you get my drift. I don't.
Grant Hill, definitely top family.
Shane Battier, top family. Yeah, listen, great. He was on a Ringer podcast recently. But Dan,
Shaq, great family.
Great family. And who's another one? Actually, as a brief aside, we had the passing of the great John Thompson this week. Maybe not, the best, upbringing, a guy named like Allen Iverson. But sometimes it takes a guy like John Thompson, a great coach, to see through the noise and to take a risk on a guy like Iverson. So I think John Thompson is a great coach, great guy. But
it takes a village, as Hillary Clinton once wrote.
Yeah, but I'm not. I wanted to make sure we give John Thompson a quick shout in the podcast. The point being, you will have a legal battle, and Dan, I have this PR background. I can't for the life of me understand the Big 12's public relations steps. You can't be transparent to the President of the United States and not to your own players and parents. I think it sends the wrong message that if you're this powerful, I'll have a conversation with you. But otherwise, no, go buzz off. Go file a lawsuit if you really want your answers.
Yeah, in the end, though, a Nebraska state court is not going to compel the Big Ten Conference to schedule collegiate football this year. So I think this lawsuit, if it's not already been mooted, should have a relatively short shelf life. And I think we need to talk about the next steps. Now that the Big Ten has filed its responsive motion, I think we could expect the court either to order a reply brief from the Nebraska players' lawyers, or it should make a decision. And that decision could be either to require the University of Michigan, to require the Big Ten Conference to provide all these requested documents within the next 5 days, or to deny that request. And if she denies the request, I think that's a signal that this lawsuit is going to be very short-lived. If she grants that request, well, then what's the next step for the Big Ten? They're not going to have an immediate right of appeal, but what they might be able to do is file a motion for rehearing and/or seek extraordinary writ relief in the Nebraska courts. There are circumstances in state courts all over the country where you may not have an interlocutory appellate right, but you can file an emergency writ. They call it in Florida a petition for writ of certiorari. Most states have them, and I think you might see the Big Ten either pursue this extraordinary writ relief within the Nebraska appellate court system, or maybe try the gambit of a removal to federal court, even though that probably would fail.
So yeah, I mean, we'll keep an eye on it. I think the time frame is really tight with football, basically starting. So we'll see what comes of it. But let's put a bow in that. Dan and I will obviously keep tabs on that.